Hello, and welcome to our discussion of the Statement of Reasons form. By statute, courts are required to submit to the U.S. Sentencing Commission 5 key documents within 30 days of sentencing in every criminal case. These documents are used for data collection and research purposes. We have a 99.9% submission rate, so you all do an amazing job of getting those documents to us. Without your hard work in completing and submitting documents, we wouldn't be able to conduct the research that informs policymaking. Our commissioners rely heavily on that data when making guideline amendment decisions, so we thank you very much for all you do. One of the documents you submit to us is the Statement of Reasons, also known as AO Form 245, which details the reason the sentence was imposed, including the reasons for any sentence outside of the applicable guideline range. In addition to informing the Commission's data and research efforts, this document is sometimes used by circuit courts when cases are taken up for appellate review. A revised Statement of Reasons form, which accounts for a change in the sentencing process, takes effect on November 1, 2025. In short, the Commission amended the sentencing guidelines to remove departures from the three-step sentencing process that had been used by most courts since the Booker opinion made the guidelines advisory in 2005. Since then, the Commission observed that courts more often used variances than departures. So to reflect that reality and to simplify the sentencing process, we removed departures from the manual. Now, there's one important exception, and that is departures under Section 5K1.1 for providing substantial assistance. To reflect this change, the Commission approved and the Judicial Conference issued a revised Statement of Reasons form, which again will go into effect on November 1, 2025. This video will provide information to assist you in the completion of this important document. The form contains 8 sections, and we will review them one by one. Section 1. Court Findings on Pre-Sentence Investigation Report. There are 3 options in Section 1. Box A. The court adopts the pre-sentence investigation report without change. This box will be checked when the court adopts the guideline calculations exactly as they are contained in the pre-sentence report. Box B. The court adopts the pre-sentence investigation report with the following changes. This box will be checked anytime the court makes findings which differ from those contained in the pre-sentence report which was prepared by the probation office. When this occurs, it is very important that these findings be properly documented in sections B1 through B4. Section B1 should be completed when changes are made to the Chapter 2 calculation. Section B2 should be completed when changes are made to the Chapter 3 calculation, and Section B3 should be completed when changes are made to the Chapter 4 calculation. Section B4 should be completed when the court makes findings or has additional comments related to facts in the pre-sentence report which may have been disputed. And remember, you will fill out as many of these sections as apply to your case. Let's look at this by way of example. Say this is a drug trafficking conviction and the guideline is calculated under Section 2D1.1. Using the drug quantity table, the pre-sentence report calculates a base offense level of 22, corresponding with between 40 and 50 grams of methamphetamine. The court, however, finds that the proper drug quantity is between 30 and 40 grams of methamphetamine, corresponding with a base offense level of 20. In this situation, box B1 will be checked. The space below should contain a brief explanation such as, the court finds that the proper drug quantity is at least 30 grams but less than 40 grams of methamphetamine, resulting in a base offense level of 20. Similarly, let's say the pre-sentence report assigned a 4-level reduction under Section 3B1.2a for the defendant being a minimal participant in criminal activity. However, the court finds that the defendant was a minor participant under Section 3B1.2b and should receive a 2-level reduction rather than the 4-level reduction. In this situation, box B2 will be checked, and the space below will contain a brief explanation such as, the court finds that the defendant was a minor participant in any criminal activity and is granted a 2-level reduction under Section 3B1.2b. Box B3 operates the same way if the court makes a finding regarding the criminal history calculation, which differs from that contained in the pre-sentence report. Again, the box would be checked and a brief explanation will be entered. Box C. This box is checked when the record establishes no need for a pre-sentence investigation report, and there's also a space to document the sentencing guideline that applied in the case. Now, I realize these spaces to write in those findings are not very large. Just remember that Section 8 of this form is kind of a catch-all where you have extra space to enter information. Section 2, Court Findings on Mandatory Minimum Sentence. In this section, the court must document findings on whether any mandatory minimum penalty applied in the case. There are three options. Box A will be checked when a mandatory minimum penalty applied and the sentence imposed is at or above the applicable mandatory minimum term. Box B will be checked when a count of conviction carried a mandatory minimum penalty, but the court has determined that the mandatory minimum does not apply. There are three options under this section. The first is findings of fact in this case. This section would be completed if, for example, the government withdrew a Section 851 enhancement. The second box is for substantial assistance under 18 U.S.C. Section 3553E, and the third is for the statutory safety valve under 18 U.S.C. Section 3553F. Box C will be checked when no count of conviction carries a mandatory minimum penalty. This is probably the box you will check most often. Section 3, Plea Agreement Determination. This section is designed to capture information about the plea agreement if there is one in the case. And remember, plea agreements may be oral or written. There are three options which are pretty straightforward. Box A will be checked if there is a non-binding plea agreement, and Box B will be checked if there is a binding plea agreement under Rule 11C1C that was accepted by the court. Finally, Box C will be checked if there is no plea agreement, meaning either the defendant pled guilty without an oral or written plea agreement or was convicted following trial. Section 4, Court Determination of Guideline Range. The key to this section is entering the court's determination. This means that if in Section 1 you checked Box A, the court adopts the pre-sentence investigation report without change. You will complete this section with the information contained in the pre-sentence report. If, however, you checked Box B in Section 1, the court adopts the pre-sentence investigation report with the following changes, you will complete this section based on those findings. It's important to note here that when entering a court's determination of the guideline range, you will have already applied Sections 5G 1.1 and 5G 1.2 regarding sentencing on a single count of conviction and on multiple counts of conviction. But this is not the place to indicate any substantial assistance reductions or sentence outside of the guideline range for other reasons. This section should state the court's determination of the guideline range before these factors are considered. We'll get to those factors in Section 6. Now let's talk about a couple of practical matters here. Sometimes there will be a guideline range and a mandatory consecutive term of imprisonment, such as an 18 U.S.C. Section 924C conviction. In this situation, you would enter the court's determination of the guideline range on the other count or counts, and then you can just write beside that range something like plus a 60-month mandatory consecutive term. There is no space on the form to account for that situation, so you can just write it in. Also, supervised release is entered as a range. Due to another recent amendment to the sentencing guidelines, most of these ranges will now have no minimum requirement. So if the maximum term of supervised release is 3 years, you will enter 0 to 3 years as the range. If there is a mandatory minimum term of supervised release, then you would enter that minimum instead of 0. Section 5, Guideline Sentencing Determination. In this section, you will document whether the sentence imposed is within or outside the applicable guideline range. You will choose one of 3 boxes corresponding to whether the sentence is within the range, below the range, or above the range. Beginning with box A, the sentence is within the range. If you check this box, your next step is to determine whether the difference between the maximum and minimum of the range exceeds 24 months. If it does, you must enter the reason or reasons the sentence was imposed at that particular point within the range. This documentation is required by statute. So in this section, you may write something like, the court finds that a sentence at the low end of the guideline range is sufficient to comply with the requirements of 18 U.S.C. Section 3553A. Again, we haven't given you a lot of space here to enter that information, but a short statement is fine, and if you need more space, remember there is space in Section 8. Boxes B and C operate in essentially the same manner. If you check one of the boxes, either the sentence imposed is below or above the guideline range, you will then check one of the sub-boxes corresponding to the position of the government regarding that sentence. The options are different under box B and box C, but you should find a description to reflect the position of the government that suits your particular situation. One thing I'll point out here is that when evaluating whether the government opposed or did not oppose a sentence below or above the range, that position may have been stated in open court at sentencing or through a filing prior to sentencing. Section 6. Court reasons for imposing a sentence outside the guideline range. If in Section 5 you checked box B or box C, meaning the sentence imposed was below or above the guideline range, you must complete Section 6. Section 6 contains two parts, Part A and Part B. Now this is super important. Part A and Part B are not mutually exclusive, meaning that you may be checking both boxes. We really need to know all of the reasons for a sentence that is below or above the guideline range. So you will check all of the boxes that apply in both sections. Box A will be checked when the court sentences below the guideline range due to substantial assistance. Box B will be used to capture information when the sentence imposed is outside the guideline range for any other reason. Now more on box B. You will check as many boxes as apply in this section. You'll notice that the first box is next to the nature and circumstances of the offense. If you check that box, then you will proceed to the sub-boxes. We need to know specifically which of those items represents the reason or reasons the court sentenced outside of the range under this factor. Again, you will check all of the appropriate boxes. Similarly, the second box is next to the history and characteristics of the defendant. If this box is checked again, you will proceed to the sub-boxes and check all of the appropriate items. I call these two sections the check plus sections, meaning if you check the first box, you need to proceed to the sub-boxes to provide the necessary details. The remaining boxes are standalone boxes. At the very bottom, a box labeled Other is provided. This page is pretty comprehensive in terms of providing the listed reasons courts sentence outside of the guideline range. In fact, in developing this form, the Commission looked back at all of the reasons courts have provided over the past 10 years for imposing a sentence outside of the range. And there is a checkbox here for 99% of those reasons. But if you do have a rare case where no other category applies, you may list the reason or reasons in the Other section. Finally, I'll note that there are a few items on this page where we request specific details, and those are noted by the word specify in italics. Now, just to reiterate what I said at the beginning, there may often be occasions where you are checking box A because the court sentenced below the range because of substantial assistance, and then also sentenced outside the range for statutory factors. For example, maybe the history and characteristics of the defendant, and then specifically education or vocational skills and youthfulness of the defendant. We want to know all of the reasons behind the sentence imposed. Section 7, Court Determination of Restitution. This section provides 4 options for documenting whether restitution was ordered. Box A will be checked in cases where restitution is not applicable. In cases where restitution is ordered, the total amount ordered will be listed at B. Section C applies to cases where restitution is not ordered and contains a list of 6 statutory explanations as to why full restitution may not have been ordered. Only one box is to be checked in this section. And box D will be checked in cases where the court orders partial restitution, and this requires a brief explanation of the reasons for the partial order. Section 8, additional basis for the sentence in this case. Now, this is that catch-all section I've referenced a few times. This form doesn't contain much space in certain sections, and you may need additional room to provide sufficient detail of the basis for certain findings. So this is the place where you can do that. Now let's talk a little bit about the very bottom of page 4, where you will enter information about the defendant and the court. Just a couple of pointers here. Defendant's residence address. Here we're looking for the last place a defendant resided before arrest or voluntary surrender. So we're not looking for the BOP facility or the local place of pretrial detention. We want to know the address of last residence outside of custody. And if the residence address is the same as the mailing address, feel free to write same on that mailing address line. Now, court information over on the right. The only thing I'll note here is that the first line, date of imposition of judgment, is the date the sentence was pronounced in court. The bottom line, date signed, is the date the statement of reasons form is signed by the judge. These two dates may or may not be the same. Often the judge is signing this form on a date later than the actual sentencing date, so just be aware. For those of you who deal with cases involving organizational defendants, there is also a new statement of reasons form for these cases, the AO Form 245E. I'm not going to review that form here. We have on our website, ussc.gov, a wonderful e-learning course called Basics of the Organizational Guidelines. We will link the AO Form 245E to that e-learning course. So again, ussc.gov under the Education tab. We've also developed a step-by-step guide to completing the Statement of Reasons form. This guide details the same steps we've just reviewed and is linked below. Please reference this document as needed as you are completing the Statement of Reasons form. And if you have any additional questions, please reach out to us. You may either contact us by email at askord@ussc.gov. You can also, as always, reach out to us through our helpline, which you can access on our website. Again, I thank you for the excellent work you do in completing and submitting these important documents to us. This information serves as the foundation for much of the research we do at the Commission.